Call David Tandem.
Thank you, Mr Speaker. I'd just like to begin my comments on not wishing to labour a point already well made by our Labor colleagues, and there's a terrible pun in there that was unintended. But sir, the matter, the Minister's choice of select committee does seem peculiar. Well, I would offer no sort of I don't wish to impugn the Social Services Committee in any way. I'm sure it's a splendid committee. According to the advice on our very own parliamentary website, however, the Social Services Committee considers matters relating to housing, senior citizens, social development, veterans affairs and work and income support. And I struggle to see how the content of this bill fits under that umbrella of issues to be considered by that committee. It's not a matter of academic interest. It is a genuine concern that committees build up a level of expertise, experience around specific matters to their area of interest. The Law and Order Committee, the Justice Committee are accustomed to working with legislation around offending, around courts, around corrections, with police. And I really am puzzled as to why you would not send it to one of those committees. So be it. So the Greens are supporting this bill to the select committee stage at least, essentially based on the reality that we are willing to engage with any proposition that is aimed at protecting children. It's fair to say, I think, that most forms of offending against the law will find a level of tolerance in most or in some parts of society. Traffic offences, some drug offences, breaking the rules around tax. You'll find a cohort of people who are willing to tolerate and even participate in some of those things. Sex offending against children is abhorrent, I would argue, to all New Zealanders. It's something that none of us can tolerate, nor should we. And so any mechanism which might reduce the risk to our children is something we're willing to engage in. I guess for us, the first question, we'll engage in this process in good faith. We'll endeavour to keep open minds. The first most important question is, will the establishment of a child sex offender register make our children safer? That's the evidence, that's the information we'll be looking for at the Select Committee. We'll be wanting to hear the evidence of experts. We'll be wanting to engage with the research to be persuaded that actually that is the case. Because such evidence as there is seems at best ambivalent about whether these registers actually do any good in the real world, or are they simply a means of appearing to do some good. And as I say, we will engage with that in good faith and we'll be interested to see what the outcome is. Having said that, even if that primary question is answered to our satisfaction that a register could potentially protect children, we would still have some fairly significant concerns about this bill as drafted, not least of all around the matters described in the Section 7 report from the Attorney-General that indicates that the bill as drafted is inconsistent with Section 9 and Section 26 of the Bill of Rights Act around disproportionately severe treatment. I may quote back to the Minister on that comment, but for the moment, double jeopardy, and the finding of the Attorney-General is that this bill is inconsistent in a way that cannot be justified. And that's a very serious matter. It's not a nuanced commentary, it's quite clear-cut, it's quite black and white, and that's something that would have to be attended to and remedied. Primarily about this matter that once a person is on the register for some offences, then there's no going back, it's for life. There's no possibility or no acknowledgement of reform, that a person may over time step away from offending, that the risk profile could drop to zero, and yet that person would forever be on the register. I think it's important to recognise that the register, okay, a name on a piece of paper. Actually, it's a great deal more than that. The Minister did indicate some of the implications of being on this register. Its name, date of birth, address, in the names of any children living at an address where a registered person may be living. details of any club or organisation with which they are affiliated that might also have child participation. And if you think that one through, that would include organisations like Forest and Bird. In fact, it's hard to think of any social club or group where children might not be involved. Details of motor vehicles, all and any phone numbers, details of service providers for phones, details of internet service providers, details of login names, usernames, passwords. This is an incredibly intrusive list of requirements. This is an extraordinarily comprehensive array of information about a human being. It's almost zero privacy, and the significance of that I'll come to when I mention the security or otherwise of such a register, our ability to keep such a register private. The fact that if a person chooses to travel from their place of residence, they must give 48 hours notice. They must indicate where they're going to be staying, names of any children who might be at that address. And somebody might be obliged to do this for 8 years, 15 years, for life, long past the point at which they may represent a risk to society, or particularly a risk to our children. So the cost of this legislation, or rather of maintaining such a register, has been commented on. And it's in the many hundreds of millions of dollars. Some of that burden, we understand, would fall on the policing budget, which is already inadequate. The police are already underfunded to the point where they are struggling to provide an acceptable level of service, despite their very best efforts, despite their very successful attempts to find efficiencies, to find ways to do more with less. Nevertheless, the cost of this legislation in terms of its implementation would run into the hundreds of millions of dollars. And that's okay. If that's going to actually protect our children, yeah, then the price ticket is not irrelevant, but it certainly becomes a matter of less importance. But the worst case scenario is we put this thing in place, it doesn't work, we've spent a great deal of money that could otherwise have been spent on provisions, on mechanisms that will help protect our children. Everything from education through to treatment, through to social mechanisms that might be much better use of that money than spending it on something that may or may not work. Sarah mentioned the matter of privacy, and it's been, Carmel Sepuloni, I think, outlined some of the dilemmas there. It's very difficult to have any confidence in the fact that a register of this nature would remain confidential, private, given the number of agencies that might potentially have access to it. We have rather a poor history in New Zealand, and I won't sort of sheet responsibility home to any particular government or any particular time, but we don't have a particularly good history of keeping secrets. Once information is in the domain of the public sector, it's very difficult to guarantee its long-term security. And that would be an extraordinary invasion, given, as I said, that people's login details, their passwords to get into their internet accounts, their emails, would be part of the information that could be accessible by, and indeed that could be accessed by people who ought not to do that. So Section 39 of the bill as it's drafted would be something of a deal breaker for the Greens. It says that the guidelines which will be prepared by the Commissioner, etc., may authorise the use of information contained in the register for a purpose other than the purpose for which the information was obtained. The criteria being that an authorised person reasonably believes such use is necessary to prevent or reduce a threat to public safety. End of story. It goes on to talk about particular concerns around protecting children, but the bottom line is that this information could, at the whim of an authorised person, be used for any purpose if they could, on the grounds that it might prevent or reduce a threat to public safety. I'd be less concerned if public safety was anywhere defined in this bill. It is not. One could draw some exceedingly long bows and provide this information on the flimsiest of excuses based on the wording of that current Section 39. I don't think that's acceptable. It's something that we couldn't, I don't think we could be part of that, and I do hope the Select Committee attends to that particular provision. The point's been made that the bill is intended to be retrospective, that it will apply to people who have been convicted before the passing of this legislation. We would have some serious reservations about that, and Jacinda Ardern in her contribution highlighted a couple of potential pitfalls where people may be captured under this legislation where in fact it was never the intention of the legislation to include those people within it. So, sir, as I say, back to where I began, we'll certainly, in good faith, engage with this. We'll look at the evidence, we'll listen to the research, we'll seek out good information, make a decision as to whether or not we think a register would actually protect our children from this most heinous of crimes, from sexual offending against them, and our actions from that point will be dependent on that information we receive. Kia ora.